All right, so I'm going to be sharing this information about election appeals, and then we're going to have some breaks partway through and just kind of throughout, and we'll talk about the different aspects of an appeals process and what you would like to see in it. So first thing I do is I share information about the way that things currently work under the Indian Act. So currently under the Indian Act, candidates and electors have 45 days to lodge an appeal, and there's 3 things that they can lodge an appeal about. And the 3 things are corrupt practice in connection with the election, a violation of the Indian Act or the Indian banned election procedure regulations that may have affected the result of the election, or an issue about a person who is nominated to be a candidate not being eligible to be a candidate. So either they're not of age or they're not considered a member. There's no fees associated with initiating an appeal under the Indian Act. I also share the alternative way that things could work if the Band Council of Witset were to decide by Band Council resolution that they want to take on the First Nations Election Act process instead and come out from under the Indian Act rules. So if the Band Council were to decide to go under the First Nations Election Act, which they have not because they've expressed instead a preference to have community make their own rules around how these things work. But if they were to go the other route, then there would be 30 days after the results of the election are announced, where an elector could file an appeal in the court to contest the election, and the basis for contesting the election would be based on there having been a contravention of the act or the regulations that's likely to have affected the result. So you see, if it's under the First Nations Election Act, 2 differences. First, that there's less things that could trigger the initiation of an appeal. So there's only one basis upon which somebody could bring an appeal. And under the Indian Act, there's 3 different bases for that. And the other thing that's different is where the appeal gets brought. So with the Indian Act, it's brought to Indigenous Services Canada, and under the First Nations Election Act, it's brought to the courts. And in the First Nations Election Act, also there would be court fees that apply. So to file a notice in the court and start a court proceeding, there would be costs associated with that. And each step of the court process, there's court fees that would be paid. Whereas under the Indian Act, if it's filed with the Indigenous Services Canada, then there's no fees associated with that process at all. So a couple of things that we want to hear from members about are, when should an appeal be allowed? So what are the different things that would trigger a person's right to file an election appeal? So this is an appeal or a challenge to the results of an election. And so a couple things that are pretty standard that people usually ask for is the same as what you see under the Indian Act. Basically, that there's been a violation of the election law or the election code that might have affected the results of the election, or a person was nominated to be a candidate that was not eligible under the rules in the election code for eligibility, which are created also by the community. So the second thing that we ask community members about is, what period of time should a person have to make the decision about filing an appeal before they can no longer do so? And a couple ideas would be 30 days or 60 days, but it would really be up to community to decide that time frame. Also, should there be fees charged for filing an appeal? And should there be an opportunity for somebody to apply for costs for frivolous appeals? So what that means is, if somebody files an appeal and it's a frivolous ground on which they make it, so they're just being petty, basically, right? They're doing it to be disruptive. There's not really any basis for the appeal. They're just kind of creating a procedural barrier unnecessarily for the people who've been elected and making life hard when there's not any reason they would ever be successful. Should there be an ability to recover the costs of the appeal from that person for what the community has suffered from a cost perspective in relation to that appeal. And what I think I'd like to do, just because we only have a few people and the presentation part of all the topics is quite short, is just continue on to appeals process and then come back to this slide and do the discussion so that Dale has less cutting to do when he's putting the video together later. So I see though that Charmaine has a hand up. Charmaine, is that okay with you, or were you wanting to talk about something right now? So I'm going to just jump into the next piece, which is about the appeals body and process. So under the Indian Act currently, as I mentioned, it goes to Indigenous Services Canada, any appeals requests, and it's the Assistant Deputy Minister who manages that process and who makes final decisions about appeals. And there are rules in the Indian Band Election Regulations that set out the process and the requirements for what type of information a person would need to provide to the Assistant Deputy Minister and the different steps that the Assistant Deputy Minister has to take when they make their decision. The process under the Indian Act is what I consider to be a private process. It's not open to the public. The documents that are filed with the Assistant Deputy Minister are not made publicly available by Indigenous Services Canada. I do know communities who've had appeals under this process where the elected chief and council make all of those documents available to their membership, but they've done that as a matter of practice, not because they're required to. There's also no cost either to the First Nations, to like the administration, for example, to participate in the appeal. And the First Nation isn't actually a party to the appeal. The appeal is brought just by the individual who's raising it. And then there's a response given by the person who the appeal is about. So say it's about a specific councillor and their conduct during the election process, and that's why the appeal is raised, then that individual person would have a right to participate in the appeal and be given a right to have notice of the issues that the appeal has to do with, as well as opportunity to respond and the reasons for the final outcome. And then when you have a band that decides to go under the First Nations Election Act, then it says in that act that a competent court hears the appeal. So the appeal could be filed either in BC Supreme Court or federal court, and it's dealt with in accordance with the particular court's rules and procedures, and each of them have their own rules and procedures that are quite a bit more complex than what I would expect the Assistant Deputy Minister to be using. And the process through the courts is public. So people would be able to access the pleadings or all like the different documents that get put before the court. The public would be allowed to access those, and the court hearing itself would be open to the public. So members would be able to go and see what's going on. And again, there's no cost to the First Nation to participate in this. Like there's no fees associated with it in that sense. And the First Nation itself is not a party to the appeal in the process itself. So when Witset is deciding what it wants to do with election appeals, the first thing one of the things it has to decide is what type of a body do we want to have for adjudication? Do we want to use the courts, or do we want to have our own decision maker that we appoint that makes these types of decisions? And there's pros and cons to each. So the pros of having your own appeals body would be that it's more accessible and convenient than a court for those who want to make an appeal, because they don't have to understand court rules and procedures in order to make the filing. They maybe they can just do it by email, for example. They don't have to go file it in a court, have specific information that, you know, the court rejects it if they don't have the right information, that type of thing. There's no direct costs to the people who are involved, in the sense that they have to pay fees unless unless they hire their own legal counsel, then they can represent themselves. The appeals body, though, the community of Witset can decide to create fees if they want to, so that is a bit of flexibility there. Having your own adjudication body can also be much faster than a court hearing, because control over the courts, but you would have control over the contract that you enter into with whoever the adjudicator is. So whoever your private decision maker is that gets hired, and you could call around and make sure you have adjudicators who have time and set it aside for the period of time where an appeal could be dealt with, so that you're not waiting until you have a court date way down the road that you're not in control of. You also would get to have your own rules of procedure that could be a lot more flexible than court rules. And for the cons, basically, the cost for the appeals body services are paid by Witset members. So if you're hiring an adjudicator, that comes out of your revenue for the band. And depending on who you decide to be the decision maker, the level of expertise that the decision maker has could vary. So there's a risk if the decision maker doesn't know how to be providing fairness to the participants. So maybe they don't provide proper notice to somebody about what's going on, or they don't provide a reasonable opportunity for the person who the appeal is about to make submissions, then there's risks that that could end up going for judicial review by the court anyways and being overturned. Other factors that the community will want to consider when it's deciding whether or not to have its own appeals body includes, having an impartial decision maker being really important. So some communities say they want to have an election appeals body that's made up of its membership. So it's kind of like a volunteer panel position. And there could be issues that arise with regards to impartiality or bias if there's that type of approach. So are you able to appoint somebody who can act without bias? And the next thing is making sure you have somebody who understands and has the ability to apply the election code and procedural fairness criteria that exist in the courts have basically said all decision-making bodies have to have procedurally fair processes. So making sure there's notice to the parties, making sure they have opportunities to be heard, proper reasons for decision, and if the person who's hearing the appeal sets out specific processes that the parties are going to have an opportunity to engage in. For example, maybe they say, okay, we're going to have an oral hearing and we're going to allow you to put witnesses forward. Then did they follow through and do that? So whatever expectations they set for the people who are involved in the process with regards to procedurally what will happen, they are expected to comply with. And if they don't, then that would be considered procedurally unfair and the decision could be challenged up the line to judicial review. And then the types of knowledge that a decision maker has to have around being able to make decisions around credibility. So is somebody telling the truth or not? And what are the different legal principles that exist that relate to that, and being able to follow a structured process for making decisions about credibility of the testimony that they hear from witnesses. Also, the ability to decide whether something is relevant evidence without getting thrown off track, basically. And last, the writing skills of the individual who's the decision maker. Can they write reasonable decisions that are justifiable, transparent, and intelligible? So do they know how to make proper findings of facts about what happened, how to apply the rules in the election code itself to those facts and put them together and figure out whether or not what happened was a breach of the election code, for example, and then write a decision that people can understand and that has a flow to it. And then I have a case that I just wanted to bring to everyone's attention just in terms of what could happen when there's a breach of procedural fairness in the way that a decision is made. So in this case, the custom election code did not work like it was meant to. And basically there was a women's council for the First Nation, and it decided to remove a candidate's name from the list of nominees who were seeking an election. And basically what happened was they did so without letting that person know that that they were doing this. So basically they raised an issue around the person's name being on the list, and then they never told the person that there was a risk of their name being taken off the list at all. They just made the decision without ever letting the person know until the decision had already been made. So what the federal court said in this circumstance was that even where only minimal procedural rights are required, they include notice and opportunity to make representation. So this is the very bare minimum that an election code can have in its process, and that it doesn't necessarily mean that the person is entitled to have an oral hearing. So it doesn't mean that they're entitled to attend in person and make oral arguments about the circumstances of the appeal, but they're entitled to some type of notice and to make submissions in some way, even if it's in writing, and that the body that's making the final decision has to give full and fair consideration of those submissions. So it has to be able to show that it contemplated the submissions and how it dealt with the arguments that were made and why it maybe disagreed or agreed with the different arguments made. And so in that case, the individual wasn't given the notice of the appeal, was not able to know that there was a case against them, and was denied an opportunity to make representations. So the federal court decided that the Women's Council has failed to observe the basic tenets of procedural fairness, the very basis of what procedural fairness is about, and that because of that, they were not provided the opportunity to run for elected council. So the federal court decided that the Women's Council's decision does not stand. So that it was turned down. It was a successful appeal, basically. And so I have 2 more slides just about appeals body to think about, and that's who do you want your appeals body to be? You could decide that you want it to be a court of competent jurisdiction, which would be either the federal court or the BC Supreme Court in our current area of British Columbia. You could decide to have a single adjudicator, which is one person who's a decision maker that makes final decisions, and they could be appointed by chief and council at the same time as the electoral officer is appointed. So that would be by the outgoing chief and council would make that decision at the time that they call the election and at the time that they appoint who's going to be the electoral officer. And you can also set out in the election code what the minimum experience level is that you want them to have with regards to the different aspects of conducting hearing and writing decisions. So you can have minimum education levels, for example, or minimum number of years as a decision maker in another context could be one of the things that you have in there. The other thing you could do is you could have your own panel or committee that you appoint that, for example, a governance, conduct, and ethics committee, but you would need to determine the eligibility criteria for who's going to sit on that committee, what rules and procedures are going to apply to it. You also need to consider things like, are they going to be able to maintain procedural fairness, write good decisions, apply the law correctly? Do we have people internally in the community who have those skills and abilities? And if not, how are we going to train them to make sure that they have all the skills and knowledge that's necessary to undertake the role? So you can have your own body that's not an adjudicator appointed who's, for example, practicing lawyer, former practicing lawyer, somebody has the skills already, but you need to think about how the training would go and how you're going to make sure those people are prepared to do the job. So when it comes to thinking about these timelines, just so you know, on the screens are made the way they are because these are the approaches that we're taking to the in-person big meetings with lots of people at them. So you can ignore the time frames. But the questions to consider are who should hear the appeal and what approach do you like best? Why do you like the approach, for example, of using the court over an adjudicator or an adjudication panel of your own members over the courts? So just thinking about kind of compare and contrast of all the different options and what it is that you want to see. And what I'm going to do is I'm going to stop the sharing. Oh, yeah, I'll stop the sharing and then I'll read the questions out so everyone can see themselves with each other when they're talking. Give me 1 second. And we'll go to the questions again. And I just want to get my document open here to document what everyone's thinking about these things. So the first question was about when an appeal should be allowed. So what types of things should trigger an appeals process to happen? Does anybody have thoughts on that?